Welcome, fellow 1Ls. Today, we are tackling the absolute beast that is contract law, specifically geared for our California baby bar. And hey, since the examiners dropped the essay portion, this explainer is strictly about high-yield, multiple-choice survival tactics. We're going to look at exactly how to quickly spot the right answers and avoid those incredibly clever traps they lay out for us. Okay, let's dive right into this. To beat the State Bar's tricky MBE-style questions, we literally have to bypass essay frameworks like IRAC. We just don't need to write out those long analyses anymore. Instead, we have to focus purely on the structural rules and the common gotchas they hide in the fact patterns. Trust me, the multiple-choice format requires a completely different kind of muscle memory. Before we start mapping out that structure, do me a huge favor and hit that like button, share this explainer with your study group, and join the channel. I'm a fellow student right here in the trenches with you, and building this community means we can conquer this exam together with a lot more real-time prep content. So here is our game plan for today. We are going to trace the life of a contract through 5 logical steps. 1. UCC or common law. 2. Contract formation basics. 3. Defenses and the statute of frauds. 4. Performance and breach. And 5. Remedies and damages. Step 1. UCC or common law. The Great Divide. This is absolutely the single most important first step, because applying the wrong rules is exactly how the examiners trap you right out of the gate. We know common law is for services, real estate, and intangibles, while UCC Article 2 is for the sale of tangible goods. But if an exam fact pattern gives you a mixed contract, say a construction company building a garage, supplying both the labor and the concrete, you must use the predominant purpose test. You figure out what the main point of the contract was and then apply that specific law to the entire dispute. Step 2. Contract formation basics, building the agreement. Let's look at how this builds into the actual mechanics of forming a valid contract. You need 3 pillars: offer, acceptance, and consideration. And remember, the bar examiners test objective theory. They do not care about a party's secret thoughts or subjective intentions. They only care about what a reasonable person would think their outward words and actions actually meant. And consideration? That's just the price of the promise. It requires a bargain for exchange of legal value, not just some gratuitous gift. But here is where it gets really interesting. What happens if the acceptance doesn't exactly match the offer? This is where the examiners absolutely love to trick us by exploiting the differences between our 2 bodies of law. Under common law, you apply the mirror image rule. Any change to the terms, no matter how tiny, is a total rejection and a counteroffer. But under the UCC, an acceptance with different terms can actually still form a contract. That's UCC 227, the battle of the forms, which often triggers the knockout rule between merchants, where conflicting terms just drop out entirely. Another huge multiple-choice trap is contract modification. Under common law, you need brand new consideration to modify a contract because of the preexisting duty rule. But under the UCC, no new consideration is needed to change a term. You literally only need mutual agreement in good faith. Always check if the contract is for goods before you assume a modification is invalid. Step 3. Defenses and the statute of frauds, the gotcha traps. Even with a perfect offer, acceptance, and consideration, the examiners will hide defenses in the facts to make a perfectly formed contract completely unenforceable. You absolutely must memorize the My Legs mnemonic for the statute of frauds: marriage, year, land, executor, goods over $500, and suretship. Pay special attention to the year trap. The rule isn't about whether performance will likely take a year. It's about whether it is completely impossible to complete within 1 year from the date of making. If it's theoretically possible to finish it in a week, it doesn't need to be in writing. And keep in mind, the statute of frauds doesn't require a formal 50-page contract with a wax seal. The examiners love to say there's no formal contract just to trick you, but a simple signed memo or even a casual email reciting the material terms can satisfy the requirement and ruin a perfectly good defense, as long as it's signed by the party to be charged, the one trying to back out of the deal. Step 4. Performance and breach. Standards of delivery. Once the contract is formed, enforceable, and past the statute of frauds, we have to look at what level of performance the law actually demands. And this is exactly why identifying the law matters from step 1. Under common law, a construction worker can get away with minor deviations through substantial performance. They still get paid, minus some damages. But a seller of goods under the UCC? No way. They must deliver exactly what was ordered under the perfect tender rule. Strict compliance is required, or the buyer can reject the whole thing. You also need to look out for anticipatory repudiation on the MBE. This is when a party unequivocally backs out of the deal before their performance is actually due. When this happens in a bilateral contract, it immediately discharges the other party's duty to perform. You don't have to sit around waiting. You can sue for breach right then and there, or you can choose to just wait until the original date to see if they change their mind. Step 5. Remedies and damages. Fixing the breach. We have reached the final stage of the contract's life cycle. Someone broke the rules, and now we need to know how the court calculates the payout. Categorize the multiple choice damage answers into 3 buckets. Expectation damages are your standard default. They put the non-breaching party in the exact position they'd be in if the contract was fully performed. If expectation damages are too uncertain, courts use reliance damages to put the party back where they started. And restitution? That's all about preventing unjust enrichment by returning the value conferred to the breacher. Watch out for specific performance as an answer choice. It is an equitable remedy only awarded when money damages just aren't going to cut it, like for the sale of unique land or one-of-a-kind art. But remember the constitutional limitation here. Specific performance is absolutely never awarded for personal service contracts. You simply cannot force someone to work for you. So, are you ready to crush the FYLSX? We've mapped out the entire life of a contract, spotted the crucial differences between the UCC and common law, and navigated the nastiest traps they can throw at us. Please like this explainer, share it with your fellow law students in the trenches, and absolutely make sure to join the channel. As a fellow student, I'll be bringing you a lot more focused, hype-free test prep exactly like this. But before you go, ask yourself this. If a merchant emails a modified offer and the buyer just texts back a thumbs up, who actually wins the battle of the forms? Keep studying smart, trust the structure, and we'll decode that in the next one.